اما قبل ما قاموا يرمون علينا اكو جماعه قاموا ينتبهوا سبرينا الذمه وهاي راح نتكتل وهاي بعض الجماعه تبوست وياهم وهاي طلعت الصوره مال بنتي اما بوستها وما تدعي رب العالمين لا تحرم المعده وهاي وانا ما عندي احد برا. بعدين قال له خلي السلاح عصلي بالشاشات والبكيسيات قال يلا نفذ العمليه. نفذوا العمليه بينا قتلونا كنا. انا ويا ما الشمارة جت هنا انا طلقه براسي وبعدين ويا ما نمت جت طلقه بدايه ان انا حسيت انا فقدتها ب5 دقائق وفقدت.
La situación de Buenaventura en sus barrios es de mucho miedo, de mucha violencia, de mucho temor.
Pues mi hijo hoy está cumpliendo 4 años desaparecido y hasta ahora no hemos sabido nada de él.
En esta región Buenaventura Pacífico, ¿sí?, no tenemos esperanza.
Hana ya wanawake ya huku kwetu Kongo, sio huku tunateseka sana. Wanaume wamekufa kwa wingi, wengine wanamke tumebakwa sana huku kwetu. Maisha imekuwa nguvu sana, tumelemelewa. Ile kitendo walinitendea nilitia buga shule. Wale wanaume wote wakisha kufika huko, orike ulikuwa abizowe ni maumivu ya sana. Ndio leo wanitendele kitendo. Tena haiko mangeta ukamata na kuna ukatana takatalia si wapi na sana kushinda. Kama kuna makisu pale wengine masira. Hakuna tabia kukatana takatala. Na yuko hata mwanaume mmoja.
뒤에다 이렇게 손 이렇게 하고 무릎 꿇고 이렇게 하고 앉으면 대가리 이거 들고 아가리 벌리라고 한단 말이에요. 그렇게 하면 거기다가 가래점 탁 받아주는데 거기서 서리 없이 그저 꿀꺽 하고 넘기면 매 안 맞고 자기도 모르게 막 뜨끈뜨끈한 게 이게 입에 들어오면 막 나도 모르게 구역질하면 거기서 그저 있는 매 없는 매 막 때리고 맞아야 된단 말이에요. 그러니까
Pendant 2 ans et demi en prison, j'ai vu mes camarades, les co-détenus, mourir de faim, mourir de soucis, mourir de torture et mourir de maladie. Du fond de ma cellule, j'ai juré devant Dieu de lutter pour la justice si je m'en sortais vivant.
I have witnessed the worst horror in the world. I lived in Block 15, and the crematoriums were right beside me. The bodies used to be stacked up. Some of them were alive. I used to hear guys laying in the ground. They'd be screaming because they couldn't get up. Well, my childhood story goes back all the way to 1939, when the Germans invaded Poland. They separated the young, the old, the crippled ones, the children, and mostly the ones that could work. One of the Germans says to me, "Wie alt bist du?" Wie alt bist du means how old you are. So I told him, "Ich bin 15." That means 15 years old. I was only 9 and a half. I was quite a big boy when I was 9.5 years old. Otherwise, I would be pushing up the daisies with my other brothers and sisters and my mother. My mother and 3 siblings went to Auschwitz. The horror that I went through when I saw my mother going on the truck with 3 other children, the horror I cannot describe to you.
Aiming to annihilate the Jewish race, Hitler's army wiped out nearly 2/3 of the total European Jewish community during World War II, including German nationals.
One of the difficulties with the laws of war is they would protect civilians living in countries attacked by the Nazi regime, but they provided no protection whatsoever to the civilians actually living in Germany. And so we had no name for this crime. We didn't know what to call it when a state attacks its own citizens. And the drafters of the Nuremberg Charter in London in 1945 hit upon this name of crimes against humanity, so that we had some criminal offense that made it a crime not only to kill the civilians in attacked areas of the world, but in the country that shared the nationality of the perpetrator. And that was revolutionary.
Crimes against humanity have been with us for some decades, since before the Nuremberg trials, but they have been defined today as huge crimes in which crimes such as violations, such as murder, extermination, torture, rape, are used specifically against a civilian population. So it's a huge crime. It's not individual acts of these crimes.
During the trial of the major war criminals at Nuremberg, a team of special prosecutors, including US Supreme Court Justice Robert Jackson, tried 22 Germans accused of crimes against peace, war crimes, and crimes against humanity.
The wrongs which we seek to condemn and punish have been so calculated, so malignant and so devastating that civilization cannot tolerate their being ignored, because it cannot survive their being repeated.
This was the first time that the term crimes against humanity was used in a strictly legal sense. The Nuremberg trial represented the idea that no one is above the law, and those who commit, order, or participate in attacks on civilians will be punished. Lieutenant Commander Whitney Harris was on Justice Jackson's team of special prosecutors at Nuremberg and led the case against Ernst Kaltenbrunner.
Kaltenbrunner oversaw the Gestapo. He oversaw the concentration camp system. Whitney was asked to go interview Rudolf Hess as part of the Kaltenbrunner case. And Whitney conducted an interview with Hess that made an extraordinary impression on him. Hess had been the commandant of Auschwitz, and he personally admitted that he had received orders and had carried out orders to kill millions of women, men, and children. Whitney couldn't forget that, and his interview of Hess was instrumental in the case against Kaltenbrunner, which the Allies won.
When you're a lawyer, you have to set aside your emotions at that point, don't you? When you interrogate a witness, no matter what he says, you're trying to get the truth. And this is very important. To get this figure out of Rudolf Hess was perhaps the most significant thing of the whole trial with respect to the Holocaust. So, you know, you just have to put that out. Now I'm emotional about it. At that time, I wasn't. I was trying to get the facts. I was happy that he told me $2.5 million, because I could put that down in the affidavit and have him sign his name to it.
Throughout history, the status quo has been the commission of terrible crimes. The Nuremberg trial tried to change that. After their conclusion, many of the prosecutors continued to dedicate their lives to making the Nuremberg dream a reality. These included Whitney Harris and Ben Ferencz, who was the chief prosecutor for one of the subsequent US military trials held in Nuremberg. Ben Ferencz tried the Einsatzgruppen case, called by some the biggest murder trial in history. It was his first case as a young lawyer. He succeeded in convicting 22 members of the Einsatzgruppen, or Nazi death squads, of murdering 1 million people between May 1941 and July 1943.
We've got to give them an alternative by building on Nuremberg, and you do that by changing the way people think. It will soon happen that everybody in the world will be literate, and they will not be blinded by some of the propaganda or the powers that exist today.
Atrocities committed during the Holocaust were prosecuted as crimes against humanity at Nuremberg, and only later came to be known as the crime of genocide. In 1948, genocide was made the subject of an international treaty known as the Genocide Convention, which criminalizes the intentional destruction of national, ethnic, racial, or religious groups. However, it was too narrow to cover other forms of crimes against humanity, such as atrocities committed by the Khmer Rouge regime in Cambodia, which largely targeted members of political groups.
Genocide and crimes against humanity are two distinct crimes. They both evolved into law from the horrors witnessed during World War II and the progress made in the field of international criminal justice from the Nuremberg and Tokyo trials onwards. Crimes against humanity, as the term suggests, are some of the worst international crimes. They are widespread and systematic attacks perpetrated against the civilian population. They include murder, enforced disappearances, enslavement, torture, rape, amongst other heinous crimes. And they occur far too often, in particular, in the context of domestic political turmoil and conflict.
The prosecution of war crimes, crimes against humanity, and genocide remains the exception rather than the rule. Since 1945, more than 300 armed conflicts have resulted in the deaths of more than 90 million people, mainly civilians. These numbers do not include victims of other atrocity crimes, such as extermination, enslavement, imprisonment, torture, sexual violence, persecution, enforced disappearance, apartheid, deportation, and forcible transfer. In fact, the UN High Commissioner for Refugees reports that by the end of 2014, nearly 60 million individuals were forcibly displaced worldwide as a result of persecution, conflict, generalized violence, or human rights violations. Yet, of an estimated 1 million perpetrators of atrocity crimes, only 1% has ever been brought to justice.
If we look at the world today, we see an unprecedented number of conflicts ongoing simultaneously. We see that there have never been, since World War II, so many internally displaced persons. So it is obvious that with those conflicts ongoing, there is a lot of accountability needed, and today the majority of those victims are not seeing any justice being done. So accountability is extremely important if we want to see societies moving forward.
Even today, 70 years following the Nuremberg trial, some governments have been accused of committing crimes against humanity. For example, by the end of the Korean War in 1953, North Korea had created its first political prison camps. Although the government denies holding political prisoners today, it is believed that there are more than 100,000 North Koreans interned in inhumane conditions in these undisclosed camps. A UN Commission of Inquiry concluded these acts constitute crimes against humanity, which, unlike war crimes, can be committed during periods of relative peace.
이성을 잃고 정신 나가는 들도 많고 거의 이렇게 죽기 직전까지 몸이 다 이렇게 쇠약해져가지고 그런 이제 살아있는 송장 같은 사람들.
많이 봤습니다. 많이 봤고 그 북한 사람 치고 공개청 안 본 사람이 없어요. 공개청 하는 장소에서 만약에 가족이라든지 그 친구가 울거나 이랬다면 그 자리에서 바로 체포돼서 부리장으로 들어가서 바로 또 총살시켜요. 왜냐면은 제가 봤을 때도 우는 사람이 없었어요.
그런 거는 안 되죠요. 어떻게 우리가 그 관리소에 들어가도 첫째 그 10가지 저항이 있는데 첫째가 그예요. 자기 죄를 묻지 말라. 이거를 알려주니까 우리가 거기 그 들어간 사람들이 다 같이 자기 죄를 모르고 거기서 사는 거예요. 재판도 없이 그런 거 없지 그죠.
The ongoing commission of atrocities in the world is why we need a new global treaty that requires states to prevent and punish crimes against humanity. Because unlike genocide and war crimes, crimes against humanity were never made the subject of their own global convention.
If you look at the core crimes that were defined in Nuremberg, we have global treaties for war crimes, for example. We have a global treaty for genocide, but we don't have it for crimes against humanity. So I think it's very important that all states realize that these are the core crimes that need to have to be given the same treatment. This either extradite or prosecute aspect of it, the obligation to enact domestic legislation on crimes against humanity. Without a treaty, it's much more difficult to do.
Only when states fully take on their responsibilities will we succeed in our collective endeavor to bring justice and accountability for victims of atrocity crimes, including crimes against humanity. A tailored treaty on crimes against humanity which enhances complementarity and advances the goals of the Rome Statute should be positively considered.
There were very few jurisdictions, if any, until recent years that had domestic jurisdiction over crimes against humanity. This was really something new at Nuremberg, and there was this gap of almost half a century before the Yugoslavia Tribunal was set up by the Security Council. But countries, nations that adopted domestic legislation to assist the Yugoslavia Tribunal, some of them incorporated crimes against humanity in their domestic law, but very few.
In states with relevant domestic legislation, we have seen how critically important building national capacity is to prosecuting international crimes. We have also seen how national prosecutions can change the status quo. The decades-long effort to bring Chilean dictator Augusto Pinochet to justice was successful when the British House of Lords held that he could be extradited to Spain to face charges of torture committed during his regime. Pinochet was ultimately sent to Chile, where he was tried by Chilean courts.
We've had some very important French cases which underscore how prosecutions can ultimately lay the groundwork for the healing of a society going forward. In the 1980s, Klaus Barbie was tried by the French for his role in torturing and murdering members of the resistance in Lyon. Barbie was a German, so it was easy for the French to try him in a sense. What was much harder is subsequently the French prosecutors took on the case of Paul Touvier, who was a Frenchman who had been accused of committing crimes against humanity against other Frenchmen during World War II. He was accused of the massacre of Villers, where 7 Jews were gunned down by French forces. Ultimately, he was convicted of crimes against humanity.
The national prosecutions are so critical because, frankly, they are the most pragmatic way to bring perpetrators to justice. If you can seek out a perpetrator in his or her own national jurisdiction, usually where they live, you immediately achieve custody, personal jurisdiction over that individual. And so just from a very pragmatic point of view, you want to make sure that you have the capacity within national legal systems to prosecute crimes against humanity, because typically that's where you're going to have the best shot at achieving custody and ultimately a trial over a perpetrator, an alleged perpetrator of these crimes.
In addition to atrocities committed by states, non-state actors have launched widespread or systematic attacks against civilian populations, committing terrible crimes, including kidnapping, rape, torture, and murder. In the Democratic Republic of the Congo, UN officials have reported that rape and sexual assault are part of an ethnic cleansing campaign carried out by rebel groups.
Ukiona kama si wa mama, Mungu alitupatia kitu kimoja kinyi tunaona kinatafutiwa na kila mtu. Sasa atafika Mkongo, anaacha ya vita, anakuwa mbia kupie. Na kwenye watenda pie, hawatatoka kule kama hawakubaka. Njumi nasema kasi wanamke. Tumekuwa maarme de guerre Mkongo.
Kaka hapa ndio ni kweli. Tukafika hapa. Tukakutana wanamke. Juu mwanamke ajue kimbii. Kumukuta unamubana, mnaingia na quelque part. Mnafanya utafanya na sama moto muo. Kisha manza mbaka unamuua mtoto, hakuna tena kuhesabia miaka. Nikamata tukatoto atakapata hivi. Tunakabaka kisha tunajende.
Most modern conflicts are occurring in a scenario where one armed group is waging war against a state. You only have to think about ISIL and how much it is present in the news today. Several years ago, you'll hear about the Revolutionary United Front in Sierra Leone or the National Patriotic Front in Liberia. This is the group that waged a war in Liberia as of 1989. Before then, you hear about Renamo in Mozambique. Before then, you hear about UNITA in Angola. You'll think about the Americas and FARC in Colombia. I mean, the list is endless of non-state actors that are involved in committing atrocity crimes.
Today, in Iraq and Syria, an armed group known as ISIL, or Daesh, is perpetrating atrocities against civilians and even using social media to broadcast its call for followers to commit executions and acts of torture and cruel treatment.
من وقفونا صاروا ورانا تقريبا مترتين عنا، مترتين 3 مترات صاروا ورانا. نفذ قال له تنفذ بالقتل، قال له تنفذ بيهم. اني ورا كان ماكو واحد بس منا ومن هنا ومكاي ماكو، بس رمى طلقات. انا سويت دعبلت وكان جوا وادي، دعبلت صرت بالاخير كلش اخير الوادي، فنمت على ظهري على وجهي، نمت ظليت نايم على وجهي، قام يرمون يرمون يرمون. انا سويت روح ميت نايم ما اتحرك.
The importance of bringing non-state actors into the realm of investigation and prosecution of crimes against humanity, whether it be at the international level or at the national level, is that these are some of the major perpetrators of these crimes in contemporary society. It would be farcical to proceed down this path and somehow hold state actors accountable, but not hold a major perpetrator of these crimes accountable. That would demonstrate a huge gap in the legal system and frankly open the doors wide for non-state actors to proceed without accountability. So you have to fill that gap.
Beginning in the 1990s, international criminal tribunals were established to try perpetrators of war crimes, genocide, and crimes against humanity in a limited number of situations. The International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, the Special Court for Sierra Leone, the Special Panels for the Prosecution of Serious Crimes in East Timor, and the Extraordinary Chambers in the Courts of Cambodia. The work of these tribunals led to a new expectation that the perpetrators of crimes against humanity will be punished. However, their limited mandates are insufficient to prosecute or deter most offenders.
We know that within our domestic experience, in any country in which we may live, the crime rate will generally depend on the efficiency or inefficiency of the criminal justice system, the police and the courts. In countries where there's an efficient, effective criminal justice system, the crime rates will be lower than those in countries where there's an inefficient criminal justice system. And I believe it's no different in the international community. If leaders know that they're likely to be investigated and prosecuted, brought before courts, if they commit crimes against humanity and other international crimes, I cannot believe that at least some of them may be deterred from that course of action.
Prosecution alone can never lead to reconciliation. Reconciliation has to come from within a society. But it's really a precondition. If there is no accountability, if those who bear the greatest responsibility have not been indicted, prosecuted, and judged, it's very, very difficult for societies to move forward together.
In 1998, with the adoption of the Rome Statute, a permanent international criminal court was established to take on many more situations, giving hope to victims that the age of impunity was over.
A huge boost was given by the adoption of the Rome Statute of the International Criminal Court, because it provides the institution for the prosecution of the crime of crimes against humanity. And it's now fully operational, and it has more than 120 countries who have signed up to the International Criminal Court.
While the ICC is still in many ways in its infancy, important empirical research has already emerged suggesting that the prospects of investigation and prosecutions in situations where the court has jurisdiction can have a cooling effect on the commission of mass crimes.
The Rome Statute defines crimes against humanity, but the International Criminal Court is a court of last resort.
Well, the ICC is based on the principle of complementarity. Ideally, the ICC should never act because it's upon states in the first place to apply the convention to prosecute and punish those guilty of crimes against humanity.
Under the Rome Statute, however, there is no explicit legal obligation for states parties to adopt domestic implementing legislation with respect to Rome Statute crimes. But of course, that is encouraged. So if this contemplated treaty does so, that would be an important advantage.
You want to have buy-in by national governments and it not be seen strictly as an international crime or an international crime that can only be prosecuted before an international tribunal. The best way to achieve this would be before national courts.
International criminal courts and tribunals hear cases about the responsibility of individuals, but for there to be effective accountability, states must be held responsible as well.
Having a Crimes Against Humanity Convention would achieve a very important sort of foundational step whereby governments have to take note, they have to perform, and if they don't, they can be held to account for it.
Following the conflict in the former Yugoslavia, the government of Bosnia brought a case to the International Court of Justice in The Hague, alleging that Serbia was responsible for more than 200,000 deaths, 50,000 rapes, and 2.2 million forcible displacements, all crimes against humanity, if proven.
The court held that only one act of genocide had been proven, that in respect of the massacre in 1995 in Srebrenica in Bosnia and Herzegovina. The court indicated that there were serious war crimes committed in other places in Bosnia and Herzegovina where certainly crimes against humanity had been committed. The court had no jurisdiction in respect of crimes against humanity because, as I've said, it was limited by the Genocide Convention. If there was an international convention for crimes against humanity, it would almost certainly also have a jurisdictional provision submitting disputes in respect of crimes against humanity to the International Court of Justice, and that would have been more appropriate.
Mungu mnasema kama watapatia malipizi wale wenye walifanya vile. Si aonaka wanasema wamepinire mtu mwenye agresere mwenye alifanya kitendo cha ubakaji wala mwenye aliua mtu wa msanctione, si aonaka. Vraiment uko Kongo haiko. Kati ule mjereuliwa anajua kama kweli kabisa kose mtu wangu bameenda mpatia malipizi. Anabakia ule mgonjwa na wakiuko na mprendre en charge kipsikolojia na unamuonesha kabisa maisha hakutaka samee. Mesa ataona tena ule mwenye alifaa vile. Ini semeni kutani kwa tembea mwingine.
In 2008, a group of committed international experts challenged the status quo. They joined the steering committee of the Crimes Against Humanity Initiative, directed by Professor Leila Sadat at Washington University in St. Louis, Missouri. Over the course of 3 years, they held a series of experts' meetings and conferences, during which more than 250 individuals were consulted in the elaboration of a proposed international convention for the prevention and punishment of crimes against humanity.
The Harris Institute has historically had a focus on human rights and global justice issues. And in 2007 and 2008, it seemed that the time was right for an initiative like that. The Harris Institute had the technical expertise to undertake a project of this magnitude. And because of the work that had been ongoing of the Institute and its reputation in this field, as well as the reputation of Washington University in St. Louis, the Harris Institute was able to draw upon a vast assortment, an array of international experts who could work with the Institute in developing the proposed convention for the prevention and suppression of crimes against humanity.
The initiative also explored mechanisms that could be included in a new treaty to help states prevent the commission of crimes against humanity. These could include provisions on state responsibility, capacity building measures, the creation of a treaty monitoring body, education and training programs for military and police, and provisions on interstate cooperation.
What we still don't have is a proper treaty that governs the obligations of states between themselves when confronted with perpetrators of crimes against humanity. They have to extradite, they have to share evidence, they have to cooperate in any number of ways. We already have models for such conventions because they also exist for torture and for enforced disappearance, but we don't yet have a general convention for crimes against humanity.
If there's a global convention that would exist in addition to the Rome Statute, with perhaps clearer obligations on stage to legislate. The ICC treaty doesn't really explicitly oblige states to do that. The treaty that is now being proposed has that really very clearly set in the treaty. So I think it will be an extra encouragement for member states of the Rome Statute to legislate, and then for those states who, for one or another reason, do not want to join the Rome Statute, they can then have it in their legislation and apply it.
In 2010, international law experts, members of civil society, and diplomats met at the Brookings Institution in Washington, D.C. They listened as Whitney Harris, then 97 years old, made this heartfelt plea.
Following the trial, Crimes Against Humanity, one of the most revolutionary and important elements of the Nuremberg Charter itself, were never set out in a treaty until the adoption of the International Criminal Court Statute in the summer of 1998. Practically speaking, what that means is that the words uttered after Nuremberg never again have but a hollow significance.
Some states have argued that the treaty is superfluous, that we don't need it, because we have the Genocide Convention and we have the Rome Statute for the International Criminal Court. The difficulty with that argument, of course, is that the Genocide Convention only covers genocide. It doesn't cover the wider scope and magnitude of crimes against humanity. As for the International Criminal Court Statute, it only provides a vertical mechanism for investigation and prosecution, and the ICC takes very few cases.
Je disais toujours aux gens que nous, en tant que survivants de torture, il nous manque quelque chose. De tout ce qu'on a vécu, vraiment, il n'y a que cette justice qui devait nous donner la vraie guérison psychologique. Hein? Parce que pour quelqu'un qui n'a pas vécu cette prison, qui n'a pas vécu cette torture, ne peut pas les comprendre.
Professor M. Sharif Bassouni, who chaired the drafting committee at the Rome Conference establishing the International Criminal Court, undertook the drafting of the proposed convention. The wording for the new convention was agreed upon by the steering committee in 2010 and published shortly thereafter. It is now available in several languages.
The convention will establish a horizontal relationship between all of the states. As it now stands, crimes against humanity means that if the ICC prosecutes and asks a state to cooperate, that state must cooperate. Now, that state is not obligated at this point to criminalize and prosecute. It has the option to do so. But with a new convention, it would have the obligation to prosecute or to extradite. So it becomes a horizontal relationship that complements the vertical relationship that exists with the ICC.
Initiatives of this character, the Crimes Against Humanity Convention, do not occur out of thin air. They occur because someone and some group of people have taken a leadership role in conceiving of them, of drafting them, negotiating these principles, and coming up with texts that survive scrutiny and ultimately achieve governmental consensus. This all means that individuals do this. People are at the core of making this happen. I think we need to recognize that at the end of the day, it's the human spirit that is reflected in these documents.
In 2013, the United Nations International Law Commission began the process of moving the idea of a new treaty on crimes against humanity from academic drawing board to political reality.
So there's a very important stage here, a very important step. The process that has been really, to date, up so far, conducted by university people, by academics, by activists and specialists, but in a non-official setting. And now we're moving it into the official realm, the International Law Commission of the United Nations, which is a body subordinate to the United Nations General Assembly. It prepares a report, it submits it to the General Assembly, and then the General Assembly can adopt the treaty.
A treaty that promotes awareness and accountability for crimes against humanity at the national level and encourages interstate cooperation on addressing these crimes. That is a positive development in my view. Ending impunity, for me, is not the preserve of any one institution.
In 2014, the International Law Commission officially added the drafting of a new treaty on crimes against humanity to its programme of work and appointed Professor Sean Murphy as special rapporteur to spearhead the effort.
The project will result in various draft articles that call upon governments to adopt national laws, to exercise jurisdiction over persons who commit crimes against humanity, and to engage in interstate cooperation on issues such as extradition and mutual legal assistance. The Commission will finish its work in the next 2 or 3 years and send forward to the UN General Assembly draft articles in the hope that the Assembly will then take them up and pursue the matter, hopefully as a new treaty. When that happens, it will be very important for governments to assess the work of the Commission, but also important for others as well. International organizations, non-governmental organizations, and even individuals should make their voices heard.
Amnesty International welcomes the development of a Convention on Crimes Against Humanity and has called on the International Law Commission to develop it in accordance with the Rome Statute of the International Criminal Court.
We're very hopeful that its time will soon come and that maybe before the year 2020, that's in about 4 years, which is pretty good for the international legal process, to have for the first time in history a convention on crimes against humanity, even though the first time that term appeared in a statute was in the International Military Tribunal, the Nuremberg Statute, in Article 6.
What has happened to me, I hope to God that you never see it. I've seen the worst horror in the world. People being knifed, people being shot, people being, when they drop on the ground, eaten by animals, people starving. All I know is one thing: the world should be a lot better with people than the way it is.
Monsieur le Président, Messieurs les juges,
derrière tout cela, derrière toutes les atrocités, les séances de torture, les formes de torture subies par des personnes, la disparition des gens, derrière tout cela, il y a un responsable. Ce responsable est bel et bien Monsieur Hissène Habré.
Hissène Habré mérite une condamnation à la hauteur des crimes dont il est déclaré coupable. C'est la raison pour laquelle, Monsieur le Président, je requiers qu'il vous plaise prononcer la condamnation de Hissène Habré à l'emprisonnement à perpétuité.
C'est ce mot de perpétuité qui résonne bien dans mon oreille. Habré, de tout ce qu'il a fait, sa vie doit finir en prison. C'est ça vraiment mon souhait. Et je crois que ça doit se confirmer.
I believe that justice is the ultimate way to correct the imbalance between those who misuse power and influence to commit such crimes to advance their interests and those they perceive as powerless who suffer at their hands. No one is above the law. The protective embrace of the law is inviolable and must not be sacrificed at the altar of political expediency.
We cannot be satisfied with the situation today where international justice is not universal, where it's not global, where you have a kind of selective international justice, a number of countries for which it is applicable, for others it is not.
I'm sure you'll find a better world built on the foundation of Nuremberg, which was an important stepping stone and should be carried forward and not neglected as it is being neglected today.
For the victims of crimes against humanity who are patiently waiting for justice, the process takes too long. But there are many constituencies that will need to be satisfied before a new treaty like this can be adopted. Civil society needs to be on board, and a significant number of the 193 members of the United Nations will have to support the treaty. So achieving consensus is going to take time. But the fact that it takes time is not an excuse for failure to take action today. For the first time in history, states and the international community are seriously considering the adoption of a new global convention on crimes against humanity, a convention that could bring the world one step closer to making the dream of never again a reality.